Yeah, let me just add a couple of things about Emily. Not only did Emily was she going to school at Pace, she was working at Fusco and Macaluso pretty much full time. We're going to school at night. Um, how she managed to do it, I have absolutely no idea. She maintained top grades, came out top of her class for the section that she was in. Um, and Emily has opened my eyes, so to speak. Most of you guys who knew me as a prosecutor know that my position when it came to immigration was uh, they didn't want to be deported. They shouldn't have come here illegally. And that's pretty much the position I took. Um, and I didn't care what the situation was. Emily, through her dedication and real passion for this work, I got to know that more when she came to work at my office. Um, really showed me that these people are not how they're portrayed and demonized in the press. I want to
Yeah.
thank Emily before we start for helping me to see that it's a different situation than what most people think immigration is all about. So Emily, thank you very much. Thank you for coming to work at my office. I was happy to steal you away from Fusco and Macaluso, and they'll never get you back.
Thank
Um,
thank you, thank you, thank you, Sal. Thank you, Joe, also.
yeah.
Um,
So
just
with that, Emily, you can go ahead and start, and we can get these people caught up to speed as much as we can.
thank you. So just to start, I want to say first and foremost, when we were doing the title and going over what we're going to present to you guys, I asked Joe to change the title from how to protect your undocumented client to how to protect your non-citizen client. Because we are talking about everybody who's not a non-citizen at this point. This is also including permanent residents. Permanent residents actually a misnomer. We'll go into that a little bit later. There are ways to lose your permanent residency if you're convicted of certain crimes, if you've been out of the United States for a certain period of time. Also, if the government determines that prior applications were submitted fraudulently. So we're talking about all non-citizens today. Quickly, what we're going to cover, we're going to go over some recent developments in immigration law and practice. Sal will talk a little bit about the recent executive orders. I know there's a lot of criminal defense attorneys here. We do have crimmigration pointers for you. Some family law consequences, because one of the big ways to gain or lose an immigration benefit is through family relation, specifically spouses, and then through divorces if they're conditional residencies. What happens if your client gets detained? How can you find your detained client? How can you bring your detained client over to municipal or superior court? The defenses after detention, and then of course some ethical consideration and self-care tips. And then hopefully we can answer any questions that you guys have. First, we just want to warn you that this is an overview. We're not going deep into immigration today. Immigration is constantly changing. We're getting new updates every day. There's lawsuits being filed every day. There's injunctions coming out. So please always check the updated directive and reports. That you can find directives on the USCIS website, on the Department of Justice website. And if you have questions, always reach out to an immigration attorney. The different agencies that we'll be talking about today a little bit and that touch immigration law. We have the Department of Homeland Security, and the USCIS is the agency that adjudicates petitions. ICE is the enforcement agency, Custom and Border Patrol, and TSA. All of these agencies at this point are going to be asked to start getting involved in enforcement. But most importantly, the two big agencies that we're hearing about and speaking about most are the Executive Office of the President and then the Executive Office for Immigration Review, which is the Immigration Court. And Sal's going to talk about the EOs.
Yeah. before I get into the EOs, Emily had that slide with the 4 agencies that are involved, and they're gonna be asked to get more involved in the immigration process, deportation, apprehension. There was just an article maybe last week. US Marshals have now been deputized to assist in doing the immigration enforcement. So not only do you have Homeland Security, you now have the Marshal Service that's also involved, and they're going to be running around with the ICE and Customs and Border Patrol doing all that. So to get into the executive orders, Article 2 of the Constitution vests the president with executive power over the government. That includes the obligation to take care that the laws are faithfully executed. What does that mean? Well, if a law signed, if an act is signed into law, it's the executive department's responsibility, the president's responsibility to make sure that that's faithfully executed. In light of that, as of January 20th, there were over 70 executive orders that were issued by President Biden, which executive orders only last as long as that person is the president, as that person who issued those orders. Next president comes in, he can rescind all those orders if he or she so wishes. But on January 20th, President Trump rescinded over 70 orders that were issued by President Biden. 15 new immigration-related executive orders were signed. Just to highlight some of those, one executive order declared a national emergency at the southern border. That declaration allowed for funds to be withdrawn from the armed services budget. So money that was already budgeted for the armed services was permitted to be taken out of their budgets and used for other purposes. In this case, it was used to allow those forces to be deployed down at the southern border. Funds that were taken away from the armed forces can now be used for wall construction. It can be used to transport immigrants and to create detention space. As you can imagine, with the number of new detainees that are coming into the system as a result of these executive orders, detention space is at a premium. I'll get into one of the detention areas later on in the slideshow that was just contracted with in Newark to provide up to 1,000 extra beds. Now, the important thing about these executive orders that affect the military, these forces can only provide assistance to Customs and Border Patrol, DHS, and TSA. They are military forces are constitutionally barred from enforcing laws within the United States. They cannot make any arrests, even for immigration purposes. They can provide logistics support only. So one of the orders talks about invasion of the southern border. So it suspends entry at the southern border for anyone that engaged in an invasion, could not provide sufficient medical information, a reliable criminal history, or background information. The one that I could understand providing sufficient medical information, and I could understand reliable criminal history or background information. Those are all things that we're all used to as attorneys. But who decides whether or not they engaged in an invasion? What is an invasion? And basically, it's a department that's being told to use common sense, but whose common sense is involved? What may be considered an invasion by one person may not be considered an invasion by another person. The military's assignment is to seal the border and repel mass migration events. What does that mean? It's those convoys of people that they periodically show on the news. That's a mass migration event. These people coming up by the thousands from different countries in South and Central America. So the military is there. You're not getting into the country if you're part of one of those convoys. Now, there was a plan that was to have been submitted within 10 days of January 20th. As far as Emily and I can tell, up to this point in time, no such plan has been put forward, other than you're sealing the border, you're not letting anybody in.
Yeah.
So
It seems
Emily,
like all of the plans have been more focused on the internal enforcement of the United States than what's been initially said on the 20th.
right, so no one knows what the actual plan is gonna be for the external. It's all what they wanna do internally. So, with that, there is the Remain in Mexico Protocol, the Migrant Protection Protocol. That was initiated pretty much before President Biden. People are required to stay in Mexico while their asylum applications are reviewed by immigration courts. During the Biden administration, there had been an app called CBP-1 that facilitated about 1 million immigrants to enter the country legally and apply for asylum. Now, as a result of these executive orders, that app has now been deleted, and it is no longer available. That happened about 1 or 2 days ago. As you can see, we have the update there. It now has an intent to depart button. What's an intent to depart button? People are there and they decided to basically self-deport. And that went into effect about 2 days ago.
Yeah, so this one I'm just going to jump in real quick. The migrant protocol protections initially came out during COVID, where they were keeping people in the United States to limit the amount of people coming into the United States as a health issue. In the Biden administration, they started using it as a means to register people and make an appointment with the Customs and Border Patrol officer to come into the United States. They stopped that immediately upon the new administration, but now they've changed the app as a means for people to self-depart. So we'll talk a little bit more about the quotas of how many people they are intending to arrest daily, but and deport daily. But one of the means that they're doing that is they're asking people that if they want to self-depart, this is how they can do that. So if you have clients that are saying, you know, I'm scared, I don't want to stay in the United States, I just want to be able to leave, they can use the CBP-1 app. Now, one of the issues that we're having with this is, of course, to self-depart, you need to have valid documents. So if the person came into the United States and their passport was seized by Customs and Border Patrol, then one of the things that we have to do as attorneys is help them get those valid documents so that they can then depart the United States. And then they'll have to deal with not having stamps in their passports and those types of issues if they intend to come back later on.
So there are a number of refugee programs that have been suspended as a result of these executive orders. Those are effective on January 27th, 2025. Now, this is not something new. We saw this back in the first Trump administration during his first term. Those refugee programs were slashed to historic lows. We anticipate that under this administration, this second Trump administration, those refugee programs are going to be slashed even further to even newer lows. Now, the good thing about it at the present time, good thing if you represent someone who's involved in the immigration system, is that there is an injunction presently in place in the district court level stopping this from taking place until the matters can be adjudicated. There are a number of injunctions that are out there. We'll talk about some of those, about one of them in particular, which affects a detention facility in Pennsylvania later on. But just know that that facility is notorious for never wanting to produce detainees, no matter what the circumstances, whether in person or via Zoom. So Um,
Yeah, then
there is more emphasis or additional emphasis now again on vetting of visa applications. As in the first term, it was going to be applied to individual applicants and to certain countries as a whole. So in the first term, you remember all the publicity this surrounded. I think it was like 7 Muslim countries, not to pick on Muslim countries, but it was 7 Muslim countries and various other countries. That's going to be applied again. It's also going to be applied to individuals. We don't have details yet on how it's going to be applied this time around, but there are cuts to funding and staffing at outside embassies, which obviously is going to affect the time it takes to vet these visa applications. But what are they doing to vet these visa applications? They're checking social media for these people who are applying for visas. They're checking emails. They're checking Facebook accounts, and they're checking WhatsApp. So if you have clients that are applying for visas, you have to let them know that anything that they're posting on any of these social media applications are going to be looked into to determine whether or not individuals are involved with or in favor of terrorist organizations or terrorist activities. I think the most recent one that everybody's probably heard about it is the graduate student from Columbia University. You know, the guy was helping people during the protests over the Gaza incursion, war, whatever you want to call it. And because the administration feels that that was aiding Hamas, which is designated as a terrorist organization, that individual is subject to having his, well, initially they told him his student visa revoked, but the young man is here on as a lawful permanent resident. When they were advised of that, they said, well, we're going to revoke that too. So they're looking into everything, and if they can tie you in any way, shape, or form to supporting, helping, or giving aid to a terrorist organization, that's going to red flag you or your application.
Yes, yes. And it's not just that. They're also looking to see if you were working while you were visiting in the United States. So that's like your Venmo and your Cash App. They're looking to see if you have dual intent when you enter the United States. So if you enter as a visitor and you intend to remain because you're looking to get married or whatever it is, they're going through all of those communications. So we are advising people if they're traveling, you know, to be wary that their phone is probably going to be checked when they come back.
Yeah, as far as the Alien Enemies Act being invoked from 1798, I have no idea. Your guess is as good as ours. I'm not picking on the administration. I'm not trying to demean the administration, but there are things that are being done and arguments that are being made every day, not just about immigration, but about other things. I think one of the biggest things that were talked about was, you know, Vice President Vance saying that, you know, maybe we won't obey court orders. So when I say we don't know what the administration is going to do, it's not because I'm trying to pick on the Trump administration. I'm against the Trump administration or for the Trump administration. We just really don't know which direction they're going to pivot to if another direction or another avenue was closed off to them. One of the biggest newsmakers was birthright citizenship. President Trump issued an executive order ending birthright citizenship as of February 20th, 2025. I personally don't think it's an order that can be enforced because it's been enshrined in the 14th Amendment. There was a case out of San Francisco, which basically held in the 1890s, I believe it was, indicating that, look, if you're born in the United States, you are a U.S. citizen, and you can invoke all your rights as a U.S. citizen by birth. Anybody born in the United States, because of the 14th Amendment, is eligible to run for president if they want. So I don't think a presidential executive, and this is my opinion, it hasn't been decided yet, but I don't think that a presidential executive order is enough to repeal a portion of an amendment that was enacted by 2/3 of the states and put in as part of the Constitution. Now, it applies to, according to this executive order, children of women that are undocumented in this country or are here temporarily, such as on a visa, if the father is not a U.S. citizen or a permanent legal resident. So if the father is a U.S. citizen or a permanent legal resident, it doesn't matter if the mother is a undocumented person here in the United States or is here on a visa, that person still has birthright citizenship. So we're waiting to see what the courts are going to do. There has been an injunction issued blocking enforcement of this executive order. So we are waiting to see what the final decision is going to be on that. I would imagine that this is something that the Supreme Court is going to want to take up as soon as possible, because it does affect a substantial number of individuals. Now, registration under 8 U.S.C. Section 1302. Everyone, there's no real change in the law with respect to registration. It's been part of the law for a long time, and it says basically it requires immigrants paroled into the United States. Now, most of us as attorneys, when we hear the word parole or paroled, think about someone who's been in prison and released and they're out there in society. That's not what it means in immigration law. In immigration law, once you come into the country, if you're inspected at the border, if you meet with Customs and Border Patrol, and you are allowed into the country, you've been paroled into the country. So that's what they're talking about when it says paroled into the U.S. Now, these individuals are advised to carry their documents with them, because if they're stopped and the documents are not in their possession, they are then subject to being detained and charged, whether they have been paroled legitimately and have these documents or not. Now, the only benefit that the added benefit that these documents have is that it provides proof that the non-citizen is here lawfully. If you have these documents, you were admitted lawfully. You weren't unlawful. You're not in the country unlawfully. Some of those documents actually state that the person named is not subject to removal. So it's important that if your client is paroled into the United States and has these documents, that they be advised that they should carry those documents. Now, who has to apply for registration? All aliens 14 years of age or older who were not registered and fingerprinted if it was required when applying for a visa to enter the United States, and who remain in the United States for 30 days or longer. They have to apply before the expiration of those 30 days. So if they're here on a visa or applied for a visa and they weren't fingerprinted or registered, then they have to apply within 30 days. The parents and legal guardians of those individuals who have not been registered, they have to apply within 30 days. And any alien, whether previously registered or not, who turns 14 years old in the United States within 14 days within 30 days after their 14th birthday. As of now, we don't have a complete process for all non-citizens to register.
Yeah.
We got this information directly from the USCIS website. It's not something, and that's what it says on the website. It doesn't really give any guidance. Emily, I don't know if you've come across anything else, but
Well, there was supposed to be some type of registration form or ability to register by February 27th. It hasn't been produced yet. So the registration requirement has always been around. It just wasn't enforced the way that it's being enforced now. And what's going to happen is they're going to be using this as a means to detain and arrest people to try and meet that arrest quota that we're going to speak about in a little bit. But to make it a little bit easier to understand, because I know people are going to be asking about this. If you are a permanent resident, if you have filed any type of application ever, if you are in removal proceedings, if you're in asylum proceedings, if you have U visas, VAWAs, anything like that, you're already registered. You're already in the system. This specific system, they're looking for people that have not had any contact with immigration, that have not had any contact with the court. You know, I do think that there's going to be pushback on this. I think that there's going to be cases filed, you know, because you are then admitting that you're in the United States without documents, and that then goes against your Fifth Amendment right against self-incrimination with some of this stuff. But right now, they don't have a process. What they've said is anybody that they believe is going to have to register is supposed to set up an account on the USCIS website. You know, we'll talk a little bit more about ethics later on, but all we can do is tell our clients what the law is and what the possible consequence of registration is. So as we get more information about this, we'll let you know.
well, employment verification. How many people have heard that are attending today's seminar have heard that these people come here and they want to take your jobs, they want to work illegally, they don't want to pay taxes. I know that's what I thought, and I've learned differently. I've learned that most of these individuals that come to this country don't want to work here, don't come here just to work here. They come here to try and get better lives for themselves and their families. And one of the things they want to do is get work authorization.
So
They want to be here and they want to work legally. They pay their taxes. You'd be surprised how many of these non-citizens who come in to get Emily's help and mine to a certain degree. The first question they ask is, how do I get my employment verification, my employment authorization? Now, the Trump administration has indicated that this is one of their priorities. They want to make sure that these people have jobs, that they're working, that they're not a public nuisance or a drain on public society, taking advantage of getting free medical care, free whatever they think that these people are getting. So our job as part of the immigration system is we always try to produce income tax returns to prove that our clients have been working legally with work authorizations. Tax returns are obviously the best proof of this. You know, these people are not public charges. They're not coming here to get welfare. They're not coming here to get Medicaid. They're coming here because they're trying to better their lives. And by being able to produce a tax return, it shows that these people are not a public charge. Now,
So this is verification, employment verification for employers. They're going to be looking for employers to produce the I-9s and the proof that the individuals are working legally. So if you have, you know, employers, specifically people that have construction companies, that they are going to be looking to make sure that everybody there has documents.
and keep in mind the work authorization, once they're here, it just gives them the right to work legally. Yeah. They get a social security number, and Emily, correct me if I'm wrong, but it's a special social security number. It's not like everybody else's. And all it does is that you can work legally, you can pay your taxes. You get no other rights. You don't have you're not entitled to any other benefit the lawful permanent resident would be entitled to. You're not entitled to any benefits the U.S. citizen would be entitled to. all you can do with a work authorization is go to work and pay your taxes. So if that's a bad thing, then I guess I'm looking at things the wrong way, but I don't see that as a bad thing. I don't know, Emily, you want to do this? You want me to do it?
Sure. So the last executive order, I think, was the withholding of the funds from sanctuary jurisdictions. And we've seen this a little bit, that the federal government stating that they will withhold funds from any jurisdiction that is not helping with enforcement. So currently there's an ICE quota, 1,500 arrests daily. They're supposed to be making 1,500 arrests daily. I know that there has been some issue with being able to arrest that many people. So some of the ways that they're doing it, we spoke a little bit about going into businesses where they're trying to find groups of people that are undocumented, but they're also using expedited removal. And expedited removal process has been a part of immigration for many, many years. It's essentially a process where a person is not given a hearing because of when they entered the United States or where they entered the United States. So historically, if the person entered the United States within the last 14 days and they're 100 miles within the border, they can be arrested and processed for expedited removal, which is essentially deportation without any hearing. I'm sorry, it's not 14 days, it's 2 years. If they're in the United States for less than 2 years and 100 miles from the border, they can be processed for expedited removal. What they're currently doing is that expedited removal area, which is considered the border region, it's that includes any international border. So it also includes international airports. So considering Newark Airport, JFK, and LaGuardia, the entire state of New Jersey would be in the expedited removal zone. So what we're telling clients is that if you're a permanent resident, of course, carry your permanent resident card. If you have any other process that's pending, carry the receipt for that process. If your client is completely undocumented, what they want to be doing is carrying some type of proof that they have at least 2 years or more in the United States, whether that be a birth certificate, a driver's license, whatever it is that proves that they've been in the United States for 2 years or more, because that 2 years in the United States will then entitle them to a hearing, whereas if not, they can be put into expedited removal proceedings. If the person is put into proceedings, they may be subject to mandatory detention. These are individuals that are not going to be eligible for bond and that are going to have to fight their entire process in detention, which I'm sure you can imagine makes things a lot more difficult, especially depending on where your client is, which we'll talk a little bit more about. The individuals that are subject to mandatory detention are those people that we just talked about in expedited removal. Also individuals that are considered arriving aliens. So these are people that they stop at the border and don't admit into the United States. Now, it's a confusing thing because somebody can be physically in the United States, their person can be here, but they're not legally admitted to the United States. So they're pending some type of status, or they're waiting to be able to produce their defense before the department. Those people are typically subject to mandatory detention. If you have non-citizens with certain criminal convictions, aggravated felonies under 8 USC 1101 A43, people with 2 or more CIMTs. A CIMT is a crime of moral turpitude. So these are specific crimes that individuals can be convicted of. They are crimes in superior court. They are crimes in municipal court. So it is important if you're dealing with a non-citizen who has a criminal case pending to speak to an immigration attorney, before taking any plea deal. Also CDS offenses, certain firearms offenses, that would be the certain non-citizens with criminal arrest, and non-citizens with prior removal orders. So these are people that have been in the United States, received a removal order, left, and came back. One of the things that's really, really confusing for my clients is that if you're stopped at the border and turned away, so you never actually made it into the United States, that's considered a removal order. So that's considered a deportation as well. So if those individuals are detained, then they're going to be subject to mandatory detention, and their entire immigration defense is going to have to be fought from within whatever facility that they're in. The big one, I know that's been on the news lately, the Laken Riley Act. This is an act that If your client is arrested, not convicted, just arrested for certain offenses, then they'll also be subject to mandatory detention. That includes theft offenses. It includes shoplifting. Just so you know, shoplifting is typically a crime of moral turpitude. So taking a shoplifting charge in municipal court can give rise to immigration problems from your client. The second part of Lake and Riley Act is that the federal government can now sue state governments for failing to enforce federal immigration law. In court, I think I've seen maybe one or two judges that have held somebody on mandatory detention. They didn't specifically say the Lake and Riley Act, but because of the theft crime. So I know that this one is being enforced.
Now, I just want to interject, Emily, for 1 second. For the guys, for the attorneys that do a lot of municipal court work, one of the things on shoplifting cases that we've tried to do to avoid that jail term, if it's a third or more, is just have it amended to a straight theft. Unfortunately, under the Lake and Riley Act, even a straight theft is now going to cause problems on the immigration end because it's a theft offense. And it's something that is going to be looked at and give rise to mandatory detention.
Yes. Yes. This one's really tough. So some of the other categories of individuals that they're putting into expedited removal proceedings are individuals that had prior legal status, and now the government is saying we're no longer going to continue that status. There are certain individuals from certain countries, specifically Cuba, Haiti, Nicaragua, and Venezuela, that were provided with this temporary protection parole into the United States. It was 2-year parole. It was going to allow them to come in and to work for that period of time. Well, that has now been terminated. So those individuals, if they have not applied for something else within those 2 years that they were in the United States and they overstay their visa, they can be subject to mandatory to expedited removal. That's also true for individuals that had certain temporary protected status. Temporary protected status is a designation that's given by Congress for certain countries during certain times, depending on what's going on in that country at that time. So for example, there was temporary protected status for Nicaragua after certain volcano eruptions and issues that they had there because of that. So that temporary protected status would have been renewed over and over again and is now being terminated. Some of those individuals will have 20 plus years in the United States, so they might come to you and say, I had legal status, I had work authorization, I was able to travel, all these things, and now all of a sudden that status has been cut off. So if they don't find another means to apply, those people are also subject right now to removal. There is an injunction in the courts for certain countries, so we'll see how that one plays off. ICE raids. Okay.
Yeah, so here's where I was talking about that common sense approach. The acting director of ICE, Caleb Vitello, issued a directive on January 23rd, 2025. All discretion is to be applied in a common sense manner. Well, what is common sense manner? What may be common sense to me may not be common sense to Joe Del Russo. And if we are the ICE officers involved, I can be in New Jersey, Joe could be in New York, same set of facts, same circumstances. My common sense is different than his. So it is fully discretionary to that particular officer. And if you want to read the whole memo, you can go to www.dhs.gov, look for acting director Vitello's directive of January 23rd, and you can see it. And it makes about as little sense as far as I'm concerned. And that, again, is my personal opinion as what I just read. Because we are used to the law being applied the same to everybody. It's applied the same to Joe Del Russo. It's applied the same to me. But in immigration circumstances, different ICE officers can have a different meaning of what common sense is, and they can apply the law differently.
Right.
And also, it just that's how it is.
So they had certain directives before where there were priority categories. And it was so if you had somebody that was arrested for a violent crime, they were the first priority. If you had people that had multiple entries, if you had people that had arrest, and then after that, so on and so forth. At the end, of course, being people that were law abiding, paying taxes, had US citizen family members, they've done away now with all of those priority categories. And the officer, as Sal said, has determined who to arrest. ICE is now allowed to go into sensitive locations. So that directive that kept ICE out of sensitive locations, specifically schools, hospitals, church, and court, has now been rescinded. So ICE can go into those buildings. Now, there has been some litigation from certain religious organizations that have pushed back, and there was an injunction about being able to go into certain churches, but ICE is still allowed to go into schools, and ICE is still allowed to go into court. It is our understanding that the directive of the New Jersey courts is that if ICE comes in, the court's supposed to help them. So how do we then advise our non-citizen clients regarding appearances in courts? There have been reports already of people being arrested directly from the court. Of course, as attorneys, we have to advise them that they must appear in court, that failure to appear may cause a warrant, and then those warrants will go into the system which ICE has access to. However, you do, of course, have to let the client know there's a possibility that you'll be arrested. I don't know, Sal, you want to add anything about that?
Yeah, the directive that we are aware of that it's allowing ICE into the courts, they're allowed in public areas. Obviously, the courts are open to the public. You can't stop them from going into the courthouse. They are, and when I say they, ICE officers are supposed to act in such a way as not to cause a disruption of the court activities. So they're not supposed to be in sensitive places. I guess that means inside the courtroom itself. You can't walk into the courtroom and just slap cuffs on somebody and say you're under arrest for an ICE warrant. But other than that, no one's going to interfere with these officers, and I think that my understanding is that is what was enforced pre-pandemic during the first Trump administration. There's nothing really has changed from what they said. How that comports with the Attorney General directive that was issued a while back, talking about not assisting law enforcement officers, not assisting ICE, I don't know. But know that they are going to be permitted into the courthouse.
So one of the things that is working, that is helping people, is advising them of what their rights are. Of course, your Fourth, your Fifth, and your Sixth Amendment rights are still valid in terms of whether or not officer can come into the home, having to answer questions, and being able to have an attorney. We're advising our clients, if an officer comes to your home, to have them show you the court order, the arrest order, to have the order put up either to the window or underneath the door, to look at that order, to see if your name's on that order. If your name is on that order, only that person should then go outside. Of course, that they should be providing, that they should be asking whether or not they're detained. And if they're not detained, that they have the ability to walk away. One of the big things that is important, and this is one of the things that we're teaching schools and hospitals, is to know the difference between administrative and judicial warrants. Because of course, judicial warrants are enforceable and administrative warrants are just the ICE warrants that are not necessarily enforceable for the officers to be able to enter the home. On the screen, you'll see two different warrants. One of the big ways to know which one is a judicial warrant is right on top of it, it'll say United States District Court, whereas the ICE warrant is going to say United States Department of Immigration and Custom Enforcement. It'll normally say I-200 or I-205 on the bottom of it, and it won't be signed by a judge. That's the other big way to know. The district court warrant is going to be signed by a judge. Your ICE warrant is going to be signed by an ICE officer. So they do use these warrants administratively, but they use them as intimidation as well. And if somebody's coming to the house, or coming to your office or anything like that with an ICE warrant, that warrant would not be one that I would follow. So it's important to know the difference between judicial and administrative warrants, especially when dealing with organizations or sensitive areas.
Now, the little red card that was in the previous slide at the bottom,
Go back.
you can create them yourself or you can order them. If you order them, they're from, and I don't get anything, and neither does Emily. This is where we got them from, and then we started doing our own as well. www.ilrc.org/red-cards. They are pre-laminated. They are also front or back, depending on which way you look at it. One's English, one's in Spanish. I'm pretty sure when I went on that website that if you need them in other languages are also available.
Yeah, I think they have 9 different languages on there.
Yeah,
The
but
Immigrant Legal Resource Center.
we Emily and I both feel that there's no ethical violation by us advising our clients that they have the right to tell these officers these particular things because they are part of the Constitution, part of the Fifth Amendment right. I don't want to talk to you. I'm not going to sign anything. I'm not going to hand you any documents. I don't give you permission to enter my home. So these are, we're not telling them to break the law. We're telling them these are your rights and you can exercise these rights. There's nothing unethical about that. It would be unethical, obviously, to tell the client, don't go to court, even if you get a subpoena or a warrant to appear in court, because that's an ethical violation. So those cards I think are very handy. People kind of feel comfortable when they have something like that, and we tell them to carry it with them. This way, whether they speak English or not, whether they speak Spanish, whether they're fluent in their own language or not, they can hand that card to whoever identifies themselves as an ICE officer, DHS officer, marshal, whatever, police officer, and tell them, I am not cooperating, I want my attorney, basically.
Yeah, we have our clients typically carry them with our business card, and then if they have contact, they can hand it to the officer. Okay, crimmigration. This is one I swear is so hard for me with the criminal defense attorneys. I always tell them the first thing to do as a criminal defense attorney is forget everything you know about criminal law when it comes to immigration. And the reason that I say that is because in immigration, your client is the respondent, the person being charged, but they also have the burden of proof. And that's very uncommon in other areas of law. Typically it's the person that's petitioning that would have the burden of proof. In civil law, you have the plaintiff. In criminal law, you have the state or the federal government, whatever it is. But here, the government's going to be charging your client, and then your client has the burden of proof to show that that they are eligible for any defense. The other big thing is that your client in immigration court is the respondent. They are not the defendant. Immigration judges get very upset, if you call your client the defendant. The other thing to know is that in immigration law, like any law, you do have a choice of counsel of your choosing, but the government's not going to pay for that. That has to be a lawyer that's either paid for by you or that an organization is going to pay for. Okay, bond is a big deal when you're dealing with immigration. And I've had this question a lot of times. If your client has a state, a criminal case, and they have an immigration detainer, and you pay the bond on that criminal case, your client is going to go directly into immigration detention. Why that matters is because they might go to Moshannon Detention Facility, but they might also send them to one of the other facilities across the country. We have guys that go to Georgia. We have guys that go to Louisiana. We got guys that get stuck in Texas. I know one attorney has a client that was sent all the way to Southern California, which makes it very, very difficult to communicate with that client, to get documents. It makes it difficult for the morale of the client because now they're moved for their family. They can't get visits. It also changes the venue, of where you're arguing the case, and then changes the choice of law that you're using in that case as well. So if you have a client that's being held on state bond, I know this doesn't happen too much in New Jersey because we have bail reform, but in some of the other states, you have to consider whether or not to pay that bond. You might want to hold that client there for a couple weeks and give the immigration attorney time to speak to the client, to collect documents, and to create a defense and initiate, work on that defense. Because once the client goes into immigration custody, they are not going to wait for the criminal case to be over to proceed with that immigration case. They're going to proceed with the immigration case first. Most likely, the client is not going to be eligible for immigration bond. We'll talk about that a little bit more, because they have that criminal case pending. And then we've been getting these guys that are stuck in this place where they've got the immigration case pending. They're stuck in ICE detention. ICE detention won't bring them over to municipal court. And now they're going to get a warrant for non-appearance. So because that was happening, there was a lawsuit specifically against Moshannon Detention Facility in Pennsylvania, which houses most of our guys. It's normally either Moshannon or Elizabeth, to cause them to produce these guys in court. So there is an injunction right now with the Moshannon Detention Facility. They do have to produce these guys for court in New Jersey, criminal court specifically. You can talk to them about, if there's a family matter or something like that, but it is specifically criminal court. We'll give you some information about how to do that. Again, because some of these guys will be stuck in mandatory detention. And those are people that are going to be inadmissible because they've committed a crime of moral turpitude, because they have aggravated felonies, drug offenses. The big number here when you're dealing with aggravated felonies, it's normally 1 year. So if your client is doing a sentence of 1 year, that's going to create, trigger, and it's one of those crimes, the aggravated felony. Just so you know, the sentence includes suspended sentences, that includes probation. So it's important to speak to an immigration attorney if your client is a non-citizen. That's why we have this slide here. We've had a lot of PCRs lately, right, Sal?
But before we do that, not only do we have the Lake and Riley Act that deals with theft offenses now, domestic violence cases are crucial. If you know that the victim wants to get the case dismissed or wants the case dismissed, get them over to the court as soon as you can. Get the case listed as soon as you can, whether it be in Superior Court, whether it be in municipal court. Now, I know the Passaic County Prosecutor's Office policy for many, many years has been that they will not dismiss a domestic violence case. What they'll normally do is downgrade it and send it back to the municipal court where it all started. So if you know that case is going back to the municipal court, get it listed as soon as you possibly can, because you want to get it on the record that it's being dismissed. No plea allocution whatsoever from your client. Just let the victim get on the record and indicate that they want to dismiss the case. Before you do an expedited expungement, do not do that unless you have a disposition letter in your hand, which says that the case was dismissed and that there was no plea. It causes issues down the road. As far as PCRs are concerned, some of the circuits require that if a PCR is being filed, and ineffective assistance of counsel is one of the claims that are being put forward, that the petitioner, your client, file a complaint against the attorney who was ineffective, an ethics complaint basically, or they will not consider those petitions. PCRs, I don't know with the new judge who's taken over. I guess it's going to be Judge Carasigi, who took over for Judge Della Carrera. But I know when Judge Della Carrera was on the bench, and I love Judge Della Carrera like a brother, but Judge Della Carrera was notorious for hardly ever, if ever, granting a post-conviction relief. It's just how judges view some of these things, and make sure, because of Lozado and Padilla And that string of cases that when you do a plea, you make sure that the client is advised, not that they may be subject to deportation, but that they will be subject to
Will be
deportation.
subject.
Because that's the key language, and the way these things are being enforced now, you are now not just maybe going to be deported, you will be deported if you have one of these cases come up in your background. So make sure that you tell your client not just that there's a chance that they're going to be deported, they will be deported. And that there are other consequences as well. That if they travel outside the country when they come back, they will be detained. We have a case that the guy was detained for coming back into the country with his fiance, and they claimed that the case that he had resolved years ago, maybe 12 years ago, was a crime involving moral turpitude, a
It was a
terroristic threat.
2007 terroristic threats
Yeah, it was a
conviction.
terroristic threat case. There's Emily was looking into it. She's a whiz, by the way, at LexisNexis, besides being a whiz at immigration. And she comes across a case which basically says terroristic threat is not a crime involving moral turpitude. So, we got the guy released, but he was in ICE custody at was it Newark Airport
Newark Airport for three
for two
days.
or three days, because this was a crime involving moral turpitude, and it's not. So make sure you tell your clients that the likelihood is almost guaranteed you're going to be detained coming back, or you're going to be deported as a result of this plea. So be very careful. And as Emily said in one of the earlier slides, before you do anything with a plea, if you have someone that you feel comfortable with contacting for immigration assistance, contact the immigration practitioners. They deal with it all day, every day. Um, they stay on top of the changes. As you can see from the slides that we did last week, Emily updated them the other day to indicate that this just happened 2 days ago. So it is a constantly changing thing, and you need someone who knows what the situation is.
Okay, we got
I
about
did
30
a piece.
slides to go through in about 15 minutes. So I just want to get
All
some of
right,
this
but I
out.
just want to say, I just did a PCR. I did a PCR in 2017 that was granted. I just ordered the transcript because I want to make sure that my client, when he applies for his expungement, has proof that the weight of the drugs involved was under 30 grams. Because there's dichotomy, federal and state law. We have 50 grams, they have 30 grams. And if you don't specify what the weight was, you're in trouble.
For
Sorry.
marijuana. Yeah, so he's specifically talking about marijuana convictions,
Yeah.
because there is a waiver for marijuana conviction under 30 grams. So that's one of those situations where we get an expungement. The case is expunged. Now the person's in some type of removal proceedings, and the New Jersey statute saying under 50. So the judge is saying, well, nothing there shows me that this guy's eligible, because it could be anywhere from 30 to 50, and then he's not eligible. So one of the things that's so important if you have a non-citizen is to hold on to those records before the case is expunged, because again, your non-citizen has the burden of proof. They have to produce those things. I can't tell you how many times an attorney is going to tell me that they're waiting for the government to produce it, and they're not going to. Family law and DV victims, just very quickly. Relationships or termination of family relationships can affect immigration status. When you're filing for non-citizen divorces, please make sure that you speak with an immigration attorney. If the individual gained their status by marriage within 2 years of the marriage, so less than 2 years from that date of marriage, it's most likely going to be a conditional residency, and then the divorce can affect that person's ability to get their permanent residency. U visas at current time are still available. Those are victims of certain crimes, which also includes domestic violence, which again, why we need to keep records. Special immigrant juvenile status is for children who are under the age of 21, who are unmarried and under the jurisdiction of the family court, who have been abused, neglected, or abandoned by one or both parents, and it's not in the best interest of that child to return. So if you have a case like that with a non-citizen child, there is a possibility of gaining status through those means. Victims of domestic violence, also VAWA petitioners, if you have situations where you have US citizens or permanent residents that are telling their non-citizen spouses, you know, they have to do X, Y, and Z, or they're going to call ICE on them, anything like that, that's also a way possibly to gain the legal status. One thing to be careful about is during the first Trump administration, there was a certification to the Attorney General's office regarding domestic violence victims and stating that they would not be covered under asylum law, and certain domestic violence victims lost protection. So that's one thing to look out for in this new administration if you have clients that have questions. Non-citizen driver's license, as we know, New Jersey provides driver's license to certain non-citizens. How this came about was that there was an issue that we would have people that would be driving, they wouldn't have driver's license, so they would have cars that were uninsured, and then there'd be accidents, and then you'd have, you know, US citizen or permanent residents that were stuck in the situation where they were hit by a car that didn't have any insurance. So New Jersey passed this law to start giving non-citizens driver's license if they were eligible. They are valid state IDs, but they're not valid federal IDs for immigration purposes. There are dangers to DWI offenses, and it's imperative that your client has consultation if they have a DWI offense. Also, one thing to know about this is it is our understanding that they're going to start using these databases as well to determine if people are undocumented in the United States. Okay, what if your client gets detained? So this is the one thing I did want to tell you guys before we finish, because I know there's a lot of people who have this question. If your client gets detained, the first thing that you want to ask them is for their A number. Immigration does not use names. You know, they'd have like 100,000 people named Jose Martinez. So they use A numbers. Your A number is going to be found on any one of your immigration documents. The notice to appear is the charging document. It's normally going to be up here where it says file number. It starts with A, and there's going to be a 9-digit number afterwards. You can Google EOIR, Automated Case Information System, and put in the A number, and this is going to tell you whether or not the person has a case that's pending in the court, or if they need to file a case that's, or if the government has not filed a notice to appear on them yet. There's an online detainee locator system. So you can Google ICE online detainee locator system. You put in your client's A number and their country of birth, and that's how you're going to find out what detention facility your client is in. There is a way to look up by name and birth date, but it's super rudimentary. And if they misspelled your client's name in any way, if they put the names together, it's going to come up as your client not being detained. So the best way to do it is with the A number and the country of birth. If your client is in Moshannon ICE Processing Center and you need to get them over to court, this is the processing center that has the injunction to produce these guys. You send an email to schedule mvpc@geogroup.com, and these slides will be available for you guys, but you can also Google Moshannon and just look at visits under the tab. You send an email there and you'll say, you know, I represent so-and-so, this is his A number, he needs to be in court on this and such a date, and they will produce that guy. You can send the link directly to them. It's Officer Matt Hartling, who's running all the video conferences. He's great. Sometimes I send the link at 9 o'clock and he produces the guys at 9:15. So he will produce them right away, and that's how you're going to get your guy to court. One thing that he asked us to do, he said, please have your attorneys email me, not call me, because they're never going to get the call. It goes to the front of the detention center. He never gets it. And please have all the attorneys keep their A numbers when they're asking to either visit, if you want to visit your client, or you're asking to bring your client over to court, because again, they have several people that might have the same names. Sal spoke a little bit about this one earlier. They are opening another ICE enforcement, an ICE facility, Delaney Hall, which I know was prior used before people were getting out of state prison to be released back but now they're going to start using that for ICE enforcement again. So that is going to be another place where you might be able to find your clients. It's my understanding that this is going to be family detention. We're not sure yet how that's going to pan out. However, we have heard word that the next layer of arrests that are coming are families. You know, they are going to be looking undocumented children. So that is something to keep in mind. That was not being enforced the last couple months. That's going to be the next layer. If your client does end up in removal proceedings, of course, this is not an exhaustive list, but the two major defenses that you have are cancellation of removal and then asylum withholding and protection under the Convention Against Torture. Cancellation of removal is eligible for both permanent residents and non-permanent residents. Oh, we do bond first. Let me do this one first. Okay. If your client is eligible for bond, we file bond separately than we're filing the immigration case. So you can file for bond without having to actually enter the immigration case. To be eligible for bond, your client has to prove that they're not flight risk, sorry, that they're not a danger to the community, and they're not a danger to the security of the United States. So that's why a lot of the times if the person has an arrest, that the judge is going to say, no, this person's considered a danger to community. But there is options for bonds. If the person is not eligible for bond, they'll have to fight their entire case inside of detention. Some of the things that you want to produce: community ties, if the person's working, if they have U.S. citizen children or spouse, if they own property. If they have criminal convictions, the judge is going to want the complaint. Now, you can strategically choose to produce things that are more or less better for your client at that point because nothing has been proved, but the judge is going to want something that says, you know, what happened. If they have any financial independence, the judge is going to want that as well. Typically, they ask us for a sponsor who's a permanent resident or U.S. citizen, and for that sponsor to produce their tax returns as well. This is just a flow chart of how the immigration process works. Once your client receives the notice to appear, they're going to get 1 or 2 master calendar hearings, which are preliminary hearings, where the judge is asking the client to respond to the charges. The client will either admit or deny the charges, and then, you know, concede or deny the allegations. I had an attorney that went in the other day, and the judge asked her how she pled, and she said guilty, and like everybody almost fell over because there's no guilt. It's you know, admitted or deny the civil charges. After the 1 or 2 preliminary hearings, where you'll be producing your defense and any application you have, then the case goes right to a final hearing. Those final hearings, if the case is approved, then of course the government has the right to appeal, but if not, then the client can normally be released within a couple weeks. If the case is denied, then the client has 30 days to appeal that case to the Board of Immigration Appeals. While that appeal is pending, they can't deport the client. He has to be stayed, but the secondary appeal after that to federal court, there's no stay to that. So your client can be in appeal, you know, and also be in the process of being deported. One thing to remember is that they have terminated a lot of DHS and judge positions. So there is a little bit of a backlog. It is taking a little bit longer. I had 2 cases that were canceled because of lack of judges. If you're someone that does federal habeas practice or wants to brush up on federal habeas practice, now is the time to do it, because if they're holding guys for a certain period of time and not moving the case, you know, you might have options to fight that detention. Okay. Humanitarian discretion has been terminated. There was a certain period of time that if your client had time in the United States, U.S. citizen children or spouses, and you know, tax returns, that we could ask the government to terminate their case because there were so many cases pending. That is not the case anymore. So they're not going to approve cases just on humanitarian factors alone. It's going to have to be that the person's eligible for one of the defenses. So the 2 big defenses are cancellation of removal and then the asylum-based or persecution-based defenses. Cancellation of removal is eligible for permanent residents and non-permanent residents. If you're filing for permanent residents, then the permanent resident has to be in the United States for at least 5 years. They have to have had continuous residence in the United States for at least 7 years and have not been convicted of an aggravated felony or had a prior waiver. So this is, again, why it's important to discuss any plea deal, because depending on whether or not that person has been convicted is going to affect their ability later on for cancellation of removal. There's also cancellation of removal for non-permanent residents. These are for our undocumented clients. That is 10 years continuously in the United States. Again, you have to demonstrate good moral character. So any type of arrest, DWI, can affect this one. And you have to prove extreme and unusual hardship to a qualifying U.S. citizen or permanent resident family member. The qualifying family relatives are going to be either the spouse or the child under the age of 21. So it's very specific which people are going to be eligible for this type of relief. And it's very important, again, that you have all documents to be able to produce good moral character. If your client has been arrested, to show that your client's case has been dismissed, tax returns, they're going to be looking for all of that stuff. If your client has taken any type of public funds, if they went to the hospital and they received charity care, the court's going to be looking for them to pay that back, typically before they're eligible for any type of cancellation status. I'm going to go through these quickly because I know we don't have a lot of time left. Asylum, withholding, and protection of the Convention Against Torture are all persecution-based defenses. This is typically people that are coming in, from the border, and they're filing immediately, or they're, within a few years of coming into the United States. If you come over the southern border, the only way really to prove that you're eligible to have done that without waiting for a visa is to show that you were fleeing persecution in your country of origin. And not just that you were fleeing persecution, but that persecution was based on a protected ground. The protected grounds being race, religion, nationality, political opinion, or a particular social group. And a particular social group typically means that the person has some type of characteristic that's immutable. They should not have to change it, or they cannot change it, and that they belong to a group that's particular. It has boundaries. So some of the social groups that we'll use are like victims of domestic violence. If somebody's homosexual and that's not allowed in certain countries, we'll use that. Gang-based violence typically falls into particular social groups, but you have to be careful with that one because there's a lot of case law, for and against with the gang-based violence. The one thing that's important to remember about asylum is that your client has to apply within 1 year of entry to the United States. If they're outside that 1 year of entry, they're going to lose the asylum eligibility. So if you have somebody that is a recent entry, they should see an attorney immediately. They're going to tell you they didn't know, but on the second page of that notice to appear on the back in small writing, it says that you have to apply within 1 year. They might tell you that they don't understand it because it's in English, but the law only says we have to provide notice, not that we have to provide notice in somebody's language of origin. To be eligible for asylum, you have to show either that you were persecuted in the past or that you will be persecuted in the future, that the government cannot protect you, that you cannot live somewhere else in your country, and that the persecution was based on one of those protected grounds. Now, if your guy is outside of that 1 year deadline, if he's resettled in another country, if he came through Canada, if he's had a prior frivolous finding or denial, if he's determined a national security threat or terrorism, or for certain crimes, they may be ineligible for asylum. If they're past the 1 year deadline, they can still apply for withholding of removal, which is similar to asylum, but you have to show that your risk of going back, it's more likely than not that you'll be persecuted. So essentially you have to show a 51% chance that it's the government itself, or with the acquiescence of the government, that you'll be persecuted. So it's a higher standard, a little bit more difficult. These are typically my guys from Nicaragua, Venezuela, that have governments that are specifically harming them. And then if your guy's not eligible for anything else, and he's got crimes, he's got aggravated felonies, he's re-entered, the only other thing that could possibly keep somebody in the United States would be protection under the Convention Against Torture. And this is when you're showing that you're going to be tortured directly or with the acquiescence of the government if you were returned. This is a very high burden. It's a difficult one to win. If somebody has an asylum application pending for 150 days, they're eligible to apply for work authorization, and at 180 days, they'll be eligible to receive that work authorization. They're also eligible for work authorization if they have a resident application pending. So the reason that we put this thing is because we just don't want people to get confused. A lot of the times our clients will say, but I had work authorization. Work authorization doesn't mean anything other than that there was another application pending. So it doesn't confer status to the person. There are other options if the person is immediately eligible for residency. So it's important, again, to speak to an immigration attorney. Sal, you want to talk quick about ethical considerations?
Obviously, we have an obligation to advise the clients what's required by any law. So if they get a notice to appear, we tell them what they have to do when they get a notice to appear. We advise clients that they must comply with any subpoenas, with any warrants. What the client chooses to do with the advice that we give them is completely up to the client. We're not obligated to make sure that they do it. All we're obligated to do is to advise them, look, this is the law. This is what you're required to do under the law. And if you don't do it, you're going to get arrested, and you're going to be deported. They can't force them to do it, but you advise them that this is what they have to do. So ethically, you just tell them to comply with the law.
We do expect an influx of more people that are going to have questions, especially with the loss of federal funding to some of the organizations that were helping individuals that didn't have attorneys, and we're helping the court just function. A lot of that is spilling over now to the private bar, a lot of the questions. And with that, we just want to remind everybody that self-care is very important. This stuff is stressful. You're going to have people with a lot of issues. You're going to have people that were in situations that they weren't in before, that have long-term ties to the United States, family separation, that it's very important, to keep in touch with other attorneys, to make sure that you're giving from a cup that overflows, that you're doing things to make sure that you're in a good place to be able to continue to advise your clients. And I think that's it. So
That's about it. Doug, I know that you put a question in about the subject to the jurisdiction of the United States. Look, there's one camp that says if you're a child that was born in this country and your parents or don't qualify under any of those things that would grant you birthright citizenship, you're not subject to the jurisdiction of the United States. My interpretation is different. My interpretation is if you're born in the United States and you're subject to the laws of the United States, you're subject to the jurisdiction of the United States. That's one of those areas, Doug, that is going to have to be decided by the Supreme Court. It's been 140 years since they dealt with birthright citizenship cases. So in my opinion, it's settled law. But I thought Roe versus Wade was settled law. I'm not trying to be flip, but I was in law school, and the big thing when we talk about common law was stare decisis. And you don't mess with established and law that's been set forth for many, many years. This Supreme Court, in certain areas, has thrown that to the wayside. In other areas, it's sticking by it. So not sure which way it's going to go or how they're going to interpret that language. I think most of the commentators that I've read that deal with this are much better at common law than I am. All seem to think that if you're subject to the laws of the United States, then you're subject to the jurisdiction of the United States. And that should end it. What the Supreme Court does, who knows?
Thanks, Sal. Thank you.
No problem.
Sal, at this point, I have to give everyone the program code.
Yep.
Program code is SS12. So SSS 12. And I also put it in the chat.
Thanks, Karen.
Thank you.
Thank you, Karen.
You're welcome.
Thank you.
The contact info is at the beginning of the slide. She can be reached at our, at the office number, 973-638-1790. And just ask for Emily. No specific extensions. Whoever answers the phone will transfer you to Emily if you tell us you want to talk to Emily.
Can you
and
give me that number again and I'll put it in the chat?
Yeah, it's 973-638-1790. Her email is ebendaña@bellomolaw.net. She monitors my email too, so if you want to, if you forget that one, you can email me at sbellomo@bellomolaw.net. Our fax number, if you want to send in a long fax question, is 973-206-2007.
2007?
Yes.
Thank you.
Thank you guys all for being here.
Yeah,
We
I,
appreciate giving the information.
Yeah, thanks for doing this. Interesting stuff.
Yep, great job, guys. Great job.
Thank you very
Thank you.
much. It was very interesting.
Thank you.
And
Excellent.
Sal,
Emily is, if I had an immigration question, Emily's, not because she works for me, but Emily's the person I would go to.
I would
There's a
hope
lot,
so.
there's a lot of great immigration attorneys out there. I know a few of them. You know, they have the reputation. Emily may not, but I think Emily is on a par, if not better than those individuals. How she does it, I have no idea.
Emily, can I ask you a quick question?
Sure.
You briefly mentioned family law matters, and I don't want to take up everybody's time, but I just have a quick question. If I have a client who is undocumented, illegal, he's here simply because about 12 years ago, he met a woman, they had a child together. He was here, he was on a visiting visa,
Hmm.
and shortly after the baby was born, he realized she had a bit of a drug problem and she tried to kill him in his sleep. So he got a restraining order and she was denied any parenting time without supervision. And before she could even get to supervision, she had to, jump through the hoops of, a psyche eval and all that kind of good stuff. And she just disappeared. So he's been wanting so desperately before this administration to go back to Poland with his daughter because she's very, very close to her grandmother and her aunts and uncles that are all in Poland that keep coming here to visit, but she wants to go there. And there's a court order from back in the beginning that if anybody was to have a passport, it had to be deposited with, if anybody got a passport for this child, it had to be deposited with the court. Now we were literally in the middle of having a psyche, we were basically doing a best interest evaluation on our own to ask the court for him to have sole custody because she's been nowhere to be found in the last 5-6 years. And at the very least for him to be able to get a passport. And now, am I wrong in saying like we have to stop short on all of this because he's illegal here and his daughter was born here, but he's completely illegal here.
The first thing that I would do for him is apply for VAWA. I mean, he sounds like textbook VAWA, which is
wait, what is that?
So it's
everybody I've spoke to told me his options are get married.
Oh no, this is a Violence Against Women's Act case, which is not just women, it's also men. So
Okay.
if you are being abused by a U.S. citizen spouse, so they're not married?
They're not married.
They're not. Okay, so if they're not married, then it's probably going to have to be a U visa. So it's if they were married, then he could do VAWA because it's a U.S. citizen spouse who's abusing him. If they're not married, then he can file for a U visa, which is victims of crime. He would have to get it signed off by either a prosecutor, a judge, a law enforcement officer that says this person is helping us to arrest whoever it is that committed the crime. He's filed some type of complaint, whatever it is, and then he can use that U visa to apply for temporary status. once the U visa is approved, it's typically 3 years after, then he'd be eligible to apply for residency. So I try to go
But
down.
but there was the one act of violence and then she disappeared. So there's no.
He never filed a complaint.
They got a final restraining order
Mhm.
and that's it. There's no other
So
crime.
if he's passed well, there had to be an underlying crime for the restraining order.
No, I said there's no other crime. I mean, she was convicted. There's a final restraining order in place.
Yeah. So one crime is enough for a U visa. Being the victim of one crime is enough for a U visa. But in terms of getting the passport, so your concern is that he would file for the passport and that they would determine that he's undocumented. And
Well, first of all, no, my concern is we're trying to go into court right now, into the family court
yeah,
with an illegal alien, right?
you're
Like
right.
I mean, his fear has always been like when he came, he was afraid. What happened was we were about to make a motion. And then of course she popped up out of the clear blue sky after being absent for 5 years. And she made a plea for parenting time, which was completely denied because she's in Florida somewhere. She has made no attempt. She hasn't done anything she was ordered to do. And it was all a bunch of BS and they just denied it.
And he has I'm sorry to cut you. He has more than 10 years in the United States.
It's however old his daughter is, and I want to say she's 8, so I don't think it's more than 10 years. No.
So if he hits the 10 years and he gets put into proceedings, he'd be eligible for cancellation of removal because he'd have 10 years in the United States if he has no crimes, and all this family court stuff would be evidence of extreme and unusual hardship to the U.S. citizen child. You know, if he couldn't be here to support her, there's no mother.
He was afraid because we had a hearing when the mother made the application just about a month ago, and there was a new administration, and he was petrified to come to our office to appear on Zoom because he was afraid then they'd know where he was. His other fear is he was just diagnosed with throat cancer.
Mhm.
And now he's really concerned, right? Like he's got to go into New York for treatment. Like he's an absolute wreck about what's going to happen to this child and if he's going to get deported.
Yeah. I mean, he could definitely be picked up because he's out of status. You know, this is the issue with pulling the priority categories, is that if he gets stopped, I mean, these guys, for the most part, I'm advising them not to be hanging out, you know, with people that are going to be getting arrested, not to be places. If he speaks English, and I hate to say it, but that's always he does it.
His sister-in-law has to be at every meeting.
Yeah, if he can wait it out for 2 years and he gets put in removal proceedings, he'll have a defense. If he gets put in removal proceedings now, then yeah, his option would be getting married. But if he's married in removal proceedings, they're going to scrutinize that marriage. You know,
Okay, so I'm gonna give him your number.
You can do that too.
Give him your number, okay?
And I'll explain to him.
If you could just, what they need to do, because I don't even want to proceed with what we're doing because I don't want to highlight the fact that he's here
Right.
Illegally.
How long ago was the incident with the mother of the child?
It had to be here. Wait, I'll tell you. I want to say 2017.
2017. So yeah, it's a little far back. If the judge was willing to sign off on the U visa, if an officer was willing to sign off on a U visa, the U visa would at least stop a deportation. That's one of those.
Yeah, the TRO was issued 2017. The incident occurred in 2017.
Yeah, because domestic violence is eligible for a U visa. So that's his other option I can talk to him about.
Okay. Yeah, I mean, it was
Always
bad. She came at him and stabbed him in his sleep.
Nice.
Yeah.
No, he should definitely be eligible for a U visa. That sounds he would have to get, you'd have to get judge, officer, even victim witness unit to sign off, depending on which county it is. I know Passaic works with us a lot.
I believe, oh wait, let me say.
Upton works with us. They'll normally
It
sign off.
is Bergen.
Bergen could be hit or miss, but I would ask them, see if victim witness will sign off on it.
Well, I'm gonna send them to you. And
I'll see it.
I wasn't there in 2017. I just stepped in recently.
Yeah. Yeah, but at least he might have that option.
Thank you. I appreciate it.
Of course.
So I'm gonna put your number down right now.
So Anna Maria, with respect to SASPA, you're talking about the old SASPA, the new SASPA?
The new one that includes non-domestic partners and say like if
Okay, so that's technically a VASPA.
okay. Yeah, but if it's a VASPA and there is no underlying conviction for a crime, right? Because the standard is a
Yeah.
civil standard and the person was able to get a restraining order, under that, do you any idea if that qualifies? I know, and I have so many referrals for Emily and you.
Well, good restraining orders or domestic partner. Okay.
I think, first of all, the SASPA is the Sexual Assault Survivors Protective Act, where there was no
Right.
relationship.
I'm talking about
other
the
than-
amended one,
Other
the
than
new one.
possibly a dating relationship.
Right. This is the one that
Um,
includes like cyber harassment.
Yeah, I would think that those would be covered under VAWA.
As long as they're married. So they got to be
Huh?
married.
They gotta be
Spouses.
married,
Spouses,
so
yeah.
it's not gonna be covered then.
It could be
Uh,
like spouses, or it could be parent, or it could be child. So if you have one where it's like a parent abusing a child or a child abusing a parent, those all also fall under VAWA.
Interesting. Okay.
So the VASPA, which is not a sexual thing, it could just be neighbors, for example, the VASPA won't be covered under it either because there's no married relationship or parent-child
Right.
relationship kind of thing.
Makes sense. Okay. Thank you so much. This was great. Really great. Thank you.
But they might be U visas. You might be able to get them as U visas because DVs
Yeah.
would be considered. So if they're not married, then it might be go through a victim of crime process. So for U visas, there's like a list of crimes that are eligible, and as long as
Wouldn't
it's
there
one
have
of
to be an
those,
underlying crime though? Like a conviction for an underlying crime, as opposed to just a restraining order, which is what you can get under the amended.
so not necessarily conviction, but a complaint, and the individual that helped the law officer. So helping the law officer, law enforcement officer proceed with the case would be filing complaint, telling them where this person is, what their address is, anything that would further help law enforcement arrest
Yeah,
them.
because it's the law enforcement officer or the prosecutor that's gonna have to sign off on the U visa application.
Or court official, victim witness.
I mean, Emily didn't get into it. I mean, the S visas are out there too.
Yeah.
S visa basically are for
Snitch
exactly what-
visas.
they're snitch visas. If you have a witness that's cooperating with the federal government, not subject to having been assaulted or had a crime committed against him or her, but wants to cooperate for whatever reason, the government can ask for an S visa. That's basically going to come just from them. Obviously, I mean, when I was in charge of the narcotics unit, I got a call from the U.S. Attorney's Office in Phoenix, Arizona, saying we're going to give this guy that you're prosecuting an S visa. Well, what does that mean? Well, he cooperated with a kilo case. I said, yeah, but he got arrested with 10 kilos. So just because he cooperated with a kilo case, you're going to give him an S visa? Well, he's cooperating with us, so we're giving him an S visa. So that's another thing that's out there. If you know that your client has been cooperating with the authorities, you can reach out to the AUSA or the DEA agent or whoever and ask them if they're willing to sponsor them for an S visa or submit an S visa application for them. But if people say, what does S mean? I go, that's exactly what it sounds like, snitch visa.
They do 2,000 a year, so they're very rare, but we've actually had 2 of them in the past 5 years, both drug cases. So they're out there.
Yeah, I had a client come into my office and tell me that the reason that he was in the country was because his dad, basically just had something to do with Pablo Escobar. So
But there you go.
there you go. So
He was running away from Pablo Escobar.
he was running away from Pablo Escobar, apparently. Yeah. So interesting, right? Wow.
Yeah.
Thank you.
Never know. Thank you.
All right. Well, does anybody else have any other questions? In that case, Karen, Joe, thank you for letting us do this presentation.
Yes.
Thank you all for sitting in and listening to us. I hope you gained some insight that that can help you out in your practices.
Thank you, Sal. Thank you,
Thank
Emily.
you.
Thank you.
Thank
All
you
right,
very
take care,
much.
guys.
Excellent.
Thank you, guys. Thanks, everybody. Enjoy the rest of the day.
Gosh, how do I get out of here?